In the lead up to Thanksgiving 2013, the Edwards Air Force Base community prepared for the 4-day weekend by throwing a wild party. The mission was clear: wear anything but clothes, play drinking games, rage. But some party attendees took that final piece a little too literally. Neighbors called security forces to report a loud crashing sound and screaming that woke them around 6 a.m. Security forces arrived to find a vomit-streaked car and a woman clinging to life. This is Conduct Unbecoming. I'm Erin, and I'm your host. Edwards Air Force Base is located in the western Mojave Desert, about 100 miles northeast of downtown Los Angeles, and can be found halfway between Barstow and Bakersfield on the I-40. The Air Force Base used to be a remote bombing range in the 1930s, and during World War II it grew to become a major bomber training base. Currently, it is home to the Air Force Flight Test Center. The base was the site of the first space shuttle landing and remains a backup site to the primary landing location, the Kennedy Space Center in Cape Canaveral, Florida. Edwards Air Force Base made the news, and you may remember seeing this, back in 2012, when it received the retired Space Shuttle Endeavour after a cross-country piggyback ride atop a jumbo jet. But as fascinating as I find all of their space toys, Edwards Air Force Base is still pretty remote. The base community has less than 12,000 people. There are no on-base transportation options, and off-base options are only available at the gate. The buildings are spread out widely, and typically traveling between them requires a vehicle. I'm giving all of this background because I think it helps to know just how small the social community is, and just how difficult it is to get around this base. Airman First Class, AFC, Elwood Bowen III worked in the 31st Test and Evaluation Squadron. The 31st Test and Evaluation Squadron is one of the oldest in the United States Air Force. It was originally established at Kelly Field in Texas, and headquarters shifted to Edwards Air Force Base in 1986. The squadron supports combined test and evaluation on Air Force weapon systems. They've specifically worked on the B-2 Spirit stealth bomber, the F-16 and F-22 fighters, the Boeing 747 Airborne Ballistic Laser, and the F-35A Joint Strike Fighter. But back to Elwood Bowen. In the evening of Sunday, November 24th, 2013, just 4 days before Thanksgiving, AFC Elwood Bowen, his wife, Mrs. Bowen, and Senior Airman Beebe gathered at the Bowen house to drive over to a party together. I've checked this date a couple of times, and it's not quite clear whether the fact section of the opinions are completely accurate. If it is accurate, if the party kicked off late on a Sunday night, can someone check on Edwards Air Force Base and make sure they're okay? An absolute rager on a school night sounds exhausting. This trio were invited to an ABC party. An ABC party, for the uninitiated, is an anything but clothes party. Guests are encouraged to get creative in fashioning coverings from non-clothing resources. It's the Unconventional Materials Challenge from Project Runway, but with a much smaller budget. Senior Airman Beebe wore a green bedsheet as a toga. Mrs. Bowen wore black pants and a bra top with playing cards attached. And it's unclear what AFC Bowen himself wore. The Bowens and Senior Airman Beebe were friends and had hung out previously on 4 or 5 separate occasions. People bond quickly on remote bases, and surviving kind of requires it. I think in our first 6 months on Okinawa, I was listed as the emergency contact for 3 or 4 separate families and at least 2 animals, because it had to be a non-family member, non-service member. At the party itself, they were all drinking and playing party games. It doesn't sound like there is a designated driver. AFC Bowen drank very heavily at the party and was generally described as wasted. He urinated into a bush and began vomiting, so other party attendees decided it was probably best to get him home. At around 2 a.m., Senior Airman Beebe, Mrs. Bowen, and 2 other guests from the party helped carry AFC Bowen out from the party and into his car. They drove back to the Bowen residence, and the 4 of them helped carry him inside. They placed him on the couch, put a blanket over him, tried to give him some water, and stationed a bucket nearby in case he needed to vomit some more. They'd returned in the car, but there's neither information about who drove the car to the Bowen home, nor information about how the other 2 guests got home or got back to the party. What we do know is that those 2 guests didn't stay at the Bowen household. The only 3 people that stayed were AFC Bowen, passed out on the couch, Mrs. Bowen, and Senior Airman Beebe. And Senior Airman Beebe and Mrs. Bowen kept the party going and took shots together in the kitchen, while AFC Bowen slept on the couch in the living room. About 4 hours after returning to the home, Mrs. Bowen and Senior Airman Beebe ventured to the guest bedroom together. They locked the door behind them. They were engaged in sexual activity when AFC Bowen began pounding on the door and asking if his wife was in the guest room with Senior Airman Beebe. Responding to that noise, the 2 pulled the top sheet up to cover themselves just as AFC Bowen broke the door down. He pulled the sheet off of his wife and his friend. He asked why they were naked in bed together. The question was, in large part, rhetorical. AFC Bowen became angry and slapped his wife. Senior Airman Beebe tried to intervene but wasn't able to get between the married couple. At approximately 6:04 a.m., AFC Bowen grabbed his wife by the hair. And from what I can put together from the facts that are incorporated into the appellate opinions, AFC Bowen threw his wife through the broken guest room door and into a wall. I believe after hitting the wall, she fell into a table and finally lost consciousness. She definitely went through the doorway, definitely hit a wall, and definitely hit a table, though the connections between these facts is a little sketchy in the opinions. The boom of Mrs. Bowen hitting the wall was so loud that it woke the neighbors. AFC Bowen continued striking his incapacitated wife, and she awoke enough to cry out in tremendous pain. Senior Airman Beebe said that during this beating, AFC Bowen kicked Mrs. Bowen in the face. Senior Airman Beebe attempted to intervene, and the 2 men engaged in a brief scuffle in the living room. AFC Bowen asked Senior Airman Beebe what he'd done to his wife. Senior Airman Beebe attempted to wake Mrs. Bowen, trying to figure out if she was okay. At one point, he broke away from the fight and tried to throw water on Mrs. Bowen's face to shock her into consciousness. Mrs. Bowen remained largely unresponsive. The neighbors, now awake, heard a man asking why she'd been naked in the front bedroom, and then they heard bathwater begin running. This prompted the neighbors to call security forces to report everything they'd heard so far. AFC Bowen grabbed a knife and slapped Senior Airman Beebe with the flat side of the blade, then threatened to kill him. He turned and slapped Mrs. Bowen with the knife, which caused her to yell out. AFC Bowen then held the knife against Senior Airman Beebe and again threatened to kill him. Senior Airman Beebe pulled on his clothes and ran from the home, yelling for help. He drove to get assistance from base security forces, where he reported that AFC Bowen was beating his wife and that AFC Bowen had a knife. Security forces thought that his demeanor was unusual, that it didn't seem like he was affected by the seriousness of his own report. He seemed to have control of himself and didn't seem visibly intoxicated. They did note that he had scratches on his face and also that Senior Airman Beebe arrived to make the report without socks. Senior Airman Beebe told security forces that he and Mrs. Bowen had continued drinking after arriving to the home and had gone to sleep in the guest bedroom. He told investigators that nothing sexual happened between him and Mrs. Bowen. When security forces responded to the home, they knocked on the front door. AFC Bowen answered wearing socks and sweatpants but no shirt, and he let them into the house. Upon entering, they noticed water and blood in the entryway. The security forces flight chief, Technical Sergeant Cabrera, inspected the house. She found bloodied sheets on the bed in the primary bedroom, a pillow on the floor next to the toilet, and finally, found Mrs. Bowen unconscious in the bathtub. Her head leaned against the faucet, her hair covering her face. Technical Sergeant Cabrera believed Mrs. Bowen to be dead, but soon heard Mrs. Bowen groan. They called for medical assistance, and then Technical Sergeant Cabrera and her staff sergeant lifted Mrs. Bowen out of the bathtub and placed her on the bed in the primary bedroom. She was still only partially conscious and not giving verbal responses. Technical Sergeant Cabrera asked Mrs. Bowen, "Did your husband do this to you?" Mrs. Bowen nodded to indicate that he had. Later, in trial, Mrs. Bowen indicated that her statements couldn't be reliable because she was, quote, absolutely not in her right state of mind. Emergency medical services transported Mrs. Bowen to the hospital. There, they checked her blood alcohol concentration and found it was 0.22. With a blood alcohol that high, she was likely experiencing confusion, disorientation, impaired balance, and slurred speech. But Mrs. Bowen had also suffered a subdural hematoma, a traumatic brain injury, 70% visual loss, the loss of her sense of smell, and the other lesser physical injuries like the gash and the swollen eyes that responding law enforcement noticed. The injuries to her brain were so severe that doctors had to perform a craniotomy. A craniotomy is when a part of the skull is surgically removed in order to expose the brain and create space where it can swell more safely. Back at the house, law enforcement continued processing the scene and collecting evidence. In the guest bedroom, that front bedroom with the broken-in door, they found Mrs. Bowen's black pants on the floor. Inside were her underwear, lined with a sanitary napkin. Nearby, they also found the playing card-adorned black bra that Mrs. Bowen wore to the ABC party. On the floor, next to her clothing, were a pair of black men's socks and the top sheet from the bed. Finding the socks next to Mrs. Bowen's clothing prompted law enforcement to apprehend Senior Airman Beebe. Remember, they'd noted when he'd arrived without his socks to report the assault. They knew that AFC Bowen answered the door wearing socks and sweatpants. And, well, finding these socks on the floor next to a naked woman's clothing in a room that they allegedly were only sleeping in didn't look great for Senior Airman Beebe. But detaining him was the next logical step. Out in the living room, law enforcement found apparent blood on the couch and a knife beside the television. In the kitchen, they found another knife laying out, scissors, a blue woman's nightie, and a bottle of alcohol along with 2 glasses. Outside the home, they found the car, streaked with vomit down the side. In their interview with Senior Airman Beebe, the Air Force Office of Special Investigations investigators told Senior Airman Beebe that they suspected him of sexually assaulting Mrs. Bowen. Senior Airman Beebe was in a locked room with a woman much more intoxicated than he appeared to be. She was on her period, and she was married. Laying out these facts prompted Senior Airman Beebe to change his story. He said Mrs. Bowen came on to him in the kitchen while they continued partying. While they were drinking, she kissed him and fondled him and then led him to the guest bedroom where she locked the door. Senior Airman Beebe explained that both he and Mrs. Bowen were the victims of assault by AFC Bowen. And this reveal wasn't without issues. Senior Airman Beebe admitted that this was the first time Mrs. Bowen had come on to him, and she herself later testified that she was not attracted to him and wouldn't have engaged in sexual activity with him. And Senior Airman Beebe had now just told 2 completely inconsistent stories. That's a liability at trial. But this disclosure prompted further investigation. At the conclusion of their investigation, Air Force prosecutors charged AFC Bowen with 2 specifications of assault with a dangerous weapon for slapping Mrs. Bowen and Senior Airman Beebe with a knife, 1 specification of assault consummated by battery upon his wife, 1 specification of assault consummated by battery upon Senior Airman Beebe, 1 specification of communicating a threat, and 1 specification of aggravated assault upon his wife. Elwood Bowen III pled not guilty and built his defense around the theory that Senior Airman Beebe was the one who assaulted his wife. His defense team highlighted that there were inconsistencies in Senior Airman Beebe's story, and that he testified under a grant of immunity, so he could avoid charges of adultery himself. the government called Mrs. Bowen to the stand, where she effectively testified on behalf of her husband. During cross-examination, Mrs. Bowen stated that she did not believe that her husband would harm her so gravely. This, in spite of the fact that the government counsel put on evidence of a previous incident of domestic violence, another time in which AFC Bowen had, in fact, harmed her. Mrs. Bowen testified that when she had been drunk in the past, AFC Bowen would run her a bath and tuck her into bed. And that's what she believed he was doing in the early morning hours of November 25th. She professed to having no memory of the assault, or anything after taking shots with Senior Airman Beebe in the kitchen. She did not remember Technical Sergeant Cabrera asking her if her husband assaulted her. She did not remember nodding in response to that question. AFC Bowen was convicted by a panel of officer members of one specification of aggravated assault upon his wife, and one specification of assault consummated by battery upon a fellow airman. The panel acquitted Bowen of 2 specifications of assault with a dangerous weapon, 1 specification of assault consummated by battery upon his wife, and 1 specification of communicating a threat. He was sentenced to 1 year confinement and a reduction to E1, and forfeitures in the amount of $800. The convening authority approved the sentence but waived the mandatory forfeitures for the benefit of AFC Bowen's minor child. But the effects of this case are further reaching than just military justice, and it appears that the Bowens filed for divorce in Orange County in 2022. There are a lot of good topics for a safety brief from this case, but I'll stick with one that came up a few times and suggest this. If you're going to an ABC party, don't forget the DD. AFC Bowen appealed to the Air Force Court of Criminal Appeals. He contended that his conviction was factually insufficient, as Senior Airman Beebe was the more likely culprit, and that the military judge erred in admitting Mrs. Bowen's head nod. The Air Force Court of Criminal Appeals ruled that the conviction was factually sufficient, and that the military judge had not erred in admitting the head nod. AFC Bowen further appealed the judge giving the nod to the head nod coming in to the Court of Appeals for the Armed Forces, or CAF. CAF had to decide whether the military judge erred or abused his discretion in applying the excited utterance exception to the hearsay rule in order to permit the government to introduce that Mrs. Bowen nodded her head in response to the question, "Did your husband do this?" Military Rule of Evidence 803, which mirrors Federal Rule of Evidence 803, contains the excited utterance exception to the hearsay rule. Most people think of hearsay as a rumor, but hearsay, and this will be the quick and dirty definition of it, is an out-of-court statement offered for the truth of the matter asserted. A statement can be something that is oral or written, but it can also be nonverbal conduct. In my evidence class, we either spent weeks on hearsay or it felt like we spent weeks on hearsay. Though I often repeated an out-of-court statement offered for the truth of the matter asserted in my nightmares during my second year of law school, I know that the phrase is functionally meaningless without additional explanation. So let's use a much more simple example. Let's say Alan was driving and hit a car after going through an intersection. He later finds himself at trial. Bob saw Alan run the red light just before the accident. Bob then told Charlie that he saw Alan run the red light. Whether Alan ran the red light is important, and there are 2 witnesses that could theoretically be called. Bob directly witnessed Alan running the red, and Charlie heard from Bob that Alan ran the red. Reasons may come up that make it appealing to an attorney to call Charlie to testify about what Bob told him. For example, Bob could be on vacation during trial, or maybe he got an elbow to the head during his last basketball game and lost his memory of the event. But in most cases, the attorney could not call Charlie, because Charlie's testimony would be hearsay. He would be testifying about what he heard Bob say. Common law prevented hearsay testimony because courts didn't think that hearsay evidence was sufficiently reliable. The courts prefer to simply hear from Bob about what he personally witnessed Alan do. That said, there are many exceptions to the rule prohibiting hearsay. These exceptions exist because, under exceptional circumstances, there are sufficient guarantees of trustworthiness, such that we can trust that the hearsay statement is reliable as evidence. Under the federal rules of evidence, there are 23 exceptions to hearsay, and one of them is excited utterances. An excited utterance is something that you might say in response to something that is shocking or startling, something you'd say under the stress of the moment. Something like, "Look out, we're going to crash." Implicit in this exception to hearsay is that the excited utterance is truthful because there's no opportunity to lie. You simply don't have time to think up and fabricate a false statement. The test CAF applied for excited utterance arose from the United States versus Arnold, another military justice case, and it required that, first, the statement must be spontaneous, excited, or impulsive, rather than the product of reflection and deliberation. Second, the event prompting the utterance must be startling. And third, the declarant must be under the stress of excitement caused by the event. AFC Bowen's appellate team argued that Mrs. Bowen was not in an excited state when she made the nonverbal statement, by nodding her head in response to the question. The appellate team argued that Mrs. Bowen's out-of-court statement was not sufficiently spontaneous because Technical Sergeant Cabrera's question was both highly suggestive and vague. This out-of-court statement, the nod that it was her husband who, quote, did this to her, was being offered in court to prove that it was her husband who injured her. They argued that the government's case was purely circumstantial and relied heavily on a single witness, Senior Airman Beebe, and that Senior Airman Beebe had a motive to lie. In contrast, the government argued that the judge correctly applied the law in order to conclude that the out-of-court statement was admissible hearsay under the excited utterance exception. They argued that the neighbor's testimony about a woman screaming in pain, about a man asking, "Why are you naked in the front bedroom?" alongside the condition that Mrs. Bowen was in when law enforcement arrived, established that this violent assault was both startling and stressful, and that Mrs. Bowen was still under the stress of the event when she nodded her head, confirming at a point close in time to the assault that it was her husband who hurt her. The government argued that the nod could not be the product of reflection or deliberation because she was largely unresponsive in the moments leading up to her statement. The government made clear that even if the judge erred in admitting the evidence, there was no prejudice to AFC Bowen, given the strength of the rest of their case. CAF believed that the court-martial judge failed to properly question Mrs. Bowen's mental state at the time she nodded in response to Technical Sergeant Cabrera's question. The fact that the court-martial judge determined that Mrs. Bowen was not in a position to testify at trial about her own mental state at the time of the assault undermined that same judge's finding that she was in an excited state when she nodded. CAF also worried that, given the nature and extent of her injuries, perhaps Mrs. Bowen didn't or couldn't understand what the question, "Did your husband do this to you?" meant. And maybe this is a naive interpretation. If Mrs. Bowen didn't understand the question, why would she expend the energy to answer it? If she didn't know that she was being asked a question, if she didn't know that she was being asked a yes or no question, why nod? CAF's application of the law ignored all of the external indicia of surprise or stress or excitement, and instead relied solely on the victim's ability to accurately assess, remember, and later testify to their own mental state. I've tried repeatedly to square this in my mind, CAF diving down this rabbit hole, but I keep arriving at the same friction point. If the members on CAF believed that Mrs. Bowen didn't have the mental capacity to assess her own mental state, doesn't that make this more likely to be an excited utterance? The nod wasn't something Mrs. Bowen had the capacity or opportunity to fabricate or lie about. The nod was an instinctual action responding to the question while she was under the stress of her violent assault. It was a question that she understood to be yes or no? And she nodded yes. The startling event that Mrs. Bowen suffered was that she was interrupted in the middle of a sex act with another man. Her husband became violent and threw her against the wall where she lost consciousness. Then he placed her into a bathtub and began to run cold water over her. Security forces arrived and asked her the question, moments after moving her from the cold bathtub, "Did your husband do this to you?" In episode 3, The Turner Case, the victim told multiple people that Malcolm Turner had shot her. If she hadn't survived, would this CAF panel have decided her declarations were too distant from the startling event to come in as an excited utterance, because the victim was no longer there to testify as to her own mental state? Or would the panel have looked at the other external indicia of surprise or stress or excitement? Perhaps this case, the precedent that it sets, is only narrowly applicable, where an excited utterance is in response to a question. CAF determined that the military judge did abuse his discretion by admitting the head nod without adequately considering Mrs. Bowen's mental capacity at the time in question. Whether this abuse of discretion resulted in overturning the conviction was dependent on whether admitting the head nod was materially prejudicial to AFC Bowen. To decide this, the court had to weigh the strength of the government's case, the strength of the defense, the materiality of the evidence at issue, and the quality of the evidence at issue. Weighing all of those factors, CAF declared that they lacked confidence that the panel was not influenced by the hearsay. That is, in reviewing the record of trial, the central question was who caused Mrs. Bowen's injuries. The government alleged it was AFC Bowen. The defense counsel maintained it was Senior Airman Beebe. CAF concluded that the head nod was likely material to how the court-martial panel resolved the issues in the case, that this head nod led the panel to agree with the government's version of events. Given the rest of the facts of trial that are incorporated into the appellate opinions, it's a little shocking that CAF has reduced the entirety of the panel's decision-making down to this piece of evidence. After setting aside the guilty findings, the Court of Appeals for the Armed Forces returned the case to the Judge Advocate General of the Air Force and authorized a rehearing. The government could get another crack at trying the case, but I would anticipate a rehearing to be very challenging. Mrs. Bowen was already a reluctant witness in the matter. She professed to believing her husband wouldn't hurt her, that he was taking care of her when he put her in the bathtub and ran cold water over her, and that she wouldn't have pursued Senior Airman Beebe sexually. I can't find anything to indicate whether the Air Force did in fact try AFC Bowen again. But if they did, it hasn't made it back up to the Air Force Court of Criminal Appeals. This is a case outcome that is particularly challenging. Given the nature of this case, I'm including some domestic violence resources in the show notes. As always, thank you for listening. If you enjoyed today's episode, please share it. I invite you to submit case suggestions and feedback to conductunbecomingpod@gmail.com. Join me next time when we search for the dulcet tones of wedding bells. Until then, take care. Conduct Unbecoming is a podcast where I get to talk about interesting crimes and cases that involve U.S. military service members. I research, write, and produce the podcast myself. The opinions expressed are my own, and perhaps it's obvious, Conduct Unbecoming is not approved, endorsed, or authorized by the Department of Defense.